or that sort, but that's not going to come up in this case. The arguments are still being recorded to be posted on YouTube. Keep your voices up. So far, we can hear you just fine. We have read your briefs, and we are ready to begin when you are. And I believe, let's get this going. Mr. Johnson, you'll begin.
Okay, thank you. Not sure what's wrong with the video. I apologize.
We can hear you just fine now.
Okay. I guess that's the best part. May it please the court, this is Tim Johnson. I represent the defendant appellant, Joan Jacob Thomas, in this legal malpractice case that is now up on appeal after a trial in Lorain County Common Pleas Court. I'd like to reserve 5 minutes for rebuttal, if I may.
Thank you.
And first, I need to start at the beginning, which is actually the end. And Joan Jacob Thomas, and I'll just refer to her as Joan if you don't mind, going forward, simply did not receive a fair trial. The judge has, the main problems with the case involve the expert testimony of both the plaintiff and the defendant's experts in this malpractice case. The trial judge has essentially admitted that he made a number of mistakes, which he tried to cure through remitted error ultimately at the end. Unfortunately, he not only made the initial mistake in the case in allowing this testimony to go to the jury, but he compounded that by not allowing, first, by not striking the testimony, second, by not allowing our expert, the defendant's expert, to testify or rebut it after it was in evidence, and then lastly, last and most importantly, actually, he allowed the plaintiff counsel to argue this improper testimony and a significant amount of damages in his closing argument. And all of this was to great prejudice to the defendant. I know that there's a lot of different issues here, and they all go back to the testimony by Mr. Badnell, with who, and I'm assuming that you are familiar with the facts, so I won't go into it in great detail. But ask me a question if there's anything in particular that you are confused about. But essentially, what happened is Mr. Badwell and I believe Mr. English cooked up a little scheme on their part to get testimony in, very important testimony on damages that had not been addressed in Mr. Badnell's report that was furnished to counsel and ultimately to the court.
And counsel, was that damages as to the spousal support or something more than that?
Spousal support.
Okay.
And this was a number that ultimately, in closing argument, Mr. English, after he did some massaging of the numbers himself in closing argument, came up with a $400,000, which was by far the largest portion, or the largest number put forth in the case as far as part of damages. The other claim damages, which we're obviously not admitting and didn't admit that they were in fact real damages. Even if you add all those up, and the judge in his rulings, he basically goes through those damages as well as his statements that were made at the time of directed verdict, and enumerates them. And without getting into the dollars and cents in detail, they basically only add up to $200,000. And that would be, without the spousal support, that would be the total complete universe of what the plaintiff's damages could have potentially been. And she did win it, so assuming that the jury wouldn't have changed their their verdict, that was still the most that she could have received without this testimony on the spousal support by Mr. Badnell. And then the judge compounded it by then not allowing, for a number of different reasons, but not allowing our expert, Mr. Skirba, the defendant's expert, to rebut the testimony that the judge allowed in on this issue. One of the reasons, he limited the testimony in a number of different ways, but one of the ways he limited the testimony was that he relied on what Mr. English was telling him, that there were cases out there that said that showing the transcript of a prior witness to your expert is not allowed, and it violates a separation of witnesses order. Number one, as it turned out, there was no separation of witnesses order, and the judge eventually figured that out. And number two, there are no cases like that. And so Mr. Skirba was severely limited, and the judge instructed him not to testify to anything that he learned from the transcript. And he made Mr. Skirba stick to his report and not allow him to address the additional issues that were brought up by the plaintiff's expert that were objected to.
Attorney Johnson, let me go back to expert Badnell's report. Did he raise the issue of spousal support in his expert report? I know you're saying he did not include the amount of spousal support or the length, but did he address the issue of spousal support? And if so, how does that not comply with Local Rule 11 that says, it talks about issues not raised in reports being inadmissible?
Well, quite simply, yeah, he addressed it in very, very general terms, but he did not get into any of the mechanics. He did not give opinions as to the length or the amount, which is very critical testimony. And frankly, even in his testimony, I don't know if you noted in our briefs, but he was unclear as to what the length was in his testimony, but yet Mr. English in his closing remarks actually came up and suggested what he thought was fair, not based on any expert testimony, as to the length, and which I believe he said was 10 years, without any testimony on that. In addition to, all the spousal support testimony that that he had already let into evidence improperly.
If he raised the issue in a general sense, as you just stated, didn't that put you on notice that, this is going to be an issue at the trial? Isn't that the purpose of the rule, to provide opposing counsel with some notice as to what the issues are going to be at trial?
Well, I would have to say it's a matter of degree. I mean, you can go back to the complaint, and I don't honestly know if it's specifically mentioned in there or not. I don't know if it is, but you can say in your complaint, you can raise an issue in your complaint that about something. Let's say spousal support. I mean, that doesn't put you on sufficient notice to be able to have your expert in rebuttal address those opinions. You can't just pull figures out of the air, and the whole idea is there's not supposed to be any surprise in these you know, in these proceedings, and clearly our expert, Mr. Skirbutt, would have addressed these in his report, and he was prepared to address them at trial, and the judge would not let him testify. That part of it is even more important than the initial mistake that the judge made in allowing the testimony in. A general reference to something that he didn't see that was proper doesn't really put you on notice as to exactly what it is that wasn't proper. So it's a matter of degree, Judge. I mean, I think is a fair thing to say.
Thank you.
And what's fair notice and what isn't?
Thank you. That's fine.
Good. I thought you were going to say something else. I'll continue on. And what should have happened,
Mr. Johnson, you have about 15 seconds, and
Oh.
then you'll be getting into your rebuttal time. You're welcome to keep going. I just wanted to let you know.
Sure, thanks. There's many topics in this case. What should have happened, I'll just say briefly, was that it should have been a directed verdict on that. That testimony shouldn't have come in, and there should have been a directed verdict on that very big piece of the case. And the case is just so tainted with problems, the expert problem being the largest, that it is just has to be, the verdict has to be set aside. And I will save my time for rebuttal, Judge. Thank you.
All right. Mr. English?
Yes, thank you, Your Honor. May it please the court, I represent Ann Alonso. I was also her trial counsel in this case. Mr. Johnson started with the notion that his client did not receive a fair trial, and I think that is not borne out by the record at all. Ms. Thomas received the fairest of trials. Not only did she testify at length about all the issues in the case, but she also had her prior trial counsel, or the trial counsel for her underlying client, Henry Alonso, testify. And she also brought in a claimed expert witness, James Skirbutt, who also testified about these issues. So focusing specifically on the issue that Mr. Johnson has raised, which relates to spousal support, I would point out to the court that the record shows that the testimony from Mr. Badnell, who was the plaintiff's expert, related both to child support as well as spousal support. And as the court well knows, spousal support is not a matter of calculation, but is rather a matter of consideration of the 15 or 16, depending on how you read the statute, factors in 3105.18. Mr. Badnell described at length that his assessment of the evidence, including the duration of the marriage, the age of the parties, their comparative education, and then reached a conclusion with respect to the amount of spousal support that should have been ordered in the case, including not only the amount, and I'm talking about combined child support and spousal support, but also the duration of spousal support.
Mr. English, when you say
Go ahead.
he reached the conclusion as to the amount, was his conclusion as to the amount contained within his expert report?
It was not specifically, the actual conclusion was not listed in his expert report, other than to say, that is to say, a specific monetary figure was not listed in the expert report. But
what was the purpose of the expert report then, if not then to let the other side know how much the damages were?
Well, the purpose was to address the issue of whether or not there was a breach of the standard of care. And secondly, whether or not in the expert's opinion, there was a direct and proximate relationship between the breach and damages. And what Mr. Badnell said was that the amount of spousal support was unconscionably low, which in fact is the case. During the trial, he was asked, well, what is the amount that you think that should have been ordered in the case? And I'll just point out, first of all, that Mr. Johnson never properly objected to any of the testimony that Mr. Badnell gave. He never identified any objection whatsoever to it not being in an expert report. And this expert report was prepared months before the trial. He elected never to depose Mr. Badnell. He elected to do no other discovery of Mr. Badnell. Instead, he presumed that he would somehow be successful in offering testimony from his own witness on this subject, even though he did not put anything in his own expert's report about spousal support. That issue was not addressed at all by his own expert in his expert report. And
Well,
when
Counsel, how could that not be trial tactics? I'm just looking, perhaps, and I certainly can't speak for him, but from the other side's point of view, if I'm evaluating that expert report, my thought is that you've presented standard of care, breach of standard of care, but perhaps I could get the judge to believe that you failed miserably on damages. Why would I want to fix that if I'm on the other side?
You know, there's a risk in everything you do in litigation.
Indeed.
Okay, so had he deposed Mr. Badnell, he would have learned all of these additional details. The expert report, the case law is clear that you don't have to list every conceivable fact that you've got on which you are relying for a conclusion. Mr. Badnell's conclusion was the amount of spousal support was grossly inadequate, and that it was a breach of the standard of care to allow that to have occurred. That was his expert report. If Mr. Johnson felt that this was somehow prejudicial to him, he could have certainly obtained appropriate expert testimony from his own client. So let me point out, there was something very fundamentally wrong with what Mr. Johnson just said. He said that the judge did not permit Attorney Skirbunt to testify with respect to anything that was in Mr. Badnell's report. That is incorrect. What the judge initially determined is that Mr. Skirbunt could not comment about Mr. Badnell's testimony because it was assumed that there was a separation of witnesses in the case. And without getting into the weeds, there are definitely cases that establish that an expert cannot testify about what another expert testified about if there is a separation of witnesses. But it's a red herring because there was no separation of witnesses. So Mr. Skirbunt was permitted to testify about anything pertaining to Mr. Badnell's testimony. The only thing he was prevented from doing was testifying about the calculation that Mr. Badnell made, even though there was no calculation that Mr. Badnell ever made. So in terms of the methodology that Mr. Badnell went through to determine what his opinion was as to the reasonable amount of spousal support, that is not a calculation per se. And when Mr. Skirbunt was offered the opportunity, and Mr. Johnson was offered the opportunity to ask any questions he wanted about Mr. Badnell's testimony, he declined. He said, quote, "The jury is dying here," as if somehow he interpreted that the jury would not be interested in what Mr. Skirbunt had to say. Now, ultimately, the jury obviously did not credit what Mr. Skirbunt had to say, but that opportunity was available to him. So to blame the trial judge and derivatively say that this record is so polluted with error that you must reverse a judgment that was granted by a jury after 7 days of trial is a little much. The fact of the matter is that Mr. Johnson never properly objected to the testimony that Mr. Badnell gave. And when he ultimately objected to it, the court had a little bit of a Hobson's choice. On one hand, all this testimony was already in the record. As the court said, the bell has rung, and you did not properly object to it. So now how do I fix that? And so the way the judge attempted to fix it, and I think correctly, was to permit Mr. Skirbunt to testify about everything Mr. Badnell had to say. And moreover, let's not forget, the defendant in this case is a lawyer, and she spent several days testifying about the very issue that as to the amount and duration of spousal support. So certainly she is competent to testify about that, and she had Henry Alonso's lawyer at the time testified, and Mr. Skirbunt also testified. So the jury was faced with a lot of evidence that it had on the amount of spousal support and child support, whether it was adequate or not. That evidence was competent, and ultimately the jury made a decision. And the jury said that the total damages were $550,000, which frankly is too little. But nevertheless, you know, you live by the sword, you die by the sword. So we accepted that verdict as it was. So I want to focus one more moment on the remittiture that was ordered by the trial court. We respectfully, we filed a cross appeal on this. We conditionally accepted the remittiture. The total judgment would have been $382,912. However, Mr. Johnson appealed on behalf of his client, and therefore we cross appealed. And we believe that the remittiture that the trial court ordered in this case is improper, is an abuse of discretion, and the whole issue about how the testimony came in with respect to Mr. Badnell's opinions and whether they were adequately addressed in his expert report, all of that was waived by the defendant not filing timely objections at all, and then not taking advantage of what the trial court gave it an opportunity to do, which is cross-examine or examine their own witness about what Mr. Badnell had to say. This is a matter of a little bit of sour grapes. You can't make a decision not to ask questions, and you can't make a decision not to have your own expert address matters in a timely manner, and then suggest that it is the plaintiff's fault for what you didn't do. I submit that's wrong. And I think the trial court got that wrong. And that's about all the trial court got wrong. The issue of prejudgment interest, I think, is very clear. The record is very clear. And even though Mr. Johnson hasn't even addressed it in his oral argument, the fact of the matter is PJI was properly awarded in this case. And I think that the appropriate resolution of the case is to reverse the trial court's conditional remittiture and conditional granting of a new trial based upon our acceptance of the remittiture, and reinstate the entire jury verdict of $550,000 plus interest. Thank you.
Thank you. All right, Mr. Johnson, you have about 4.5 minutes left.
Thank you, Your Honor. A couple of things that Mr. English mentioned that are not correct or not totally accurate, let's say. The fact that he is saying that I declined the judge's offer, the trial judge's offer to let Mr. Skirbunt testify further. Well, that was after, first of all, he's incorrect about what the instructions from the judge to Mr. Skirbunt were, and that was that, you know, he was not allowed to rely on that testimony that we had printed up from Mr. Badnell, mostly because of this additional information on the spousal support that he that he testified to that he shouldn't have been testifying to. And the judge, you will see in many places, admits that that testimony should not have come in. And I guess we can argue about whether he was on sufficient notice or not, but I did object. I objected to all the relevant questions, and eventually asked to approach the bench and point out in detail where, you know, the errors of what he is testifying to in the report. And what should have happened at that point in time, the judge should have struck the answer of the witness and instructed the jury not to consider it. Instead, he let it in and then compounded the error by not allowing Mr. Skirbunt to testify to that issue, and making him stay within his report, which was a rebuttal report from the plaintiff, you know, addressing the issues raised in the plaintiff's expert's report. the judge, at the end of all of Mr. Skirbutt's testimony, however long that lasted with cross-examination and everything, an hour, then asked me, well, I've changed. He said something to the effect that he changed his mind, and if I want to go back through all the testimony and have Mr. Badnell go through, have Mr. Skirbutt go through all of his questions again, and be allowed to comment on the testimony that he saw. And at that point in time, he was not allowing us, myself and Mr. Skirbutt, he was not allowing us to go into that testimony regarding the spousal support. So this was after he had discovered that there was in fact no separation of witnesses. And by the way, I did not see any cases in Mr. English's materials that verify this statement that he made to the trial court about their about not allowing transcripts of trial testimony. It's done all the time, and there are no such cases, or at least we could find no such cases. And he's absolutely positively wrong on that. We do this all the time in cases where, in the bigger cases where you get daily reports, you get daily transcripts, and the witnesses can refer to those transcripts. And if your expert is trying to rebut another expert, it's fair game to give them the accurate testimony to what the plaintiff's expert actually did testify to at trial. It leads to greater accuracy. So he's just totally, completely wrong on that issue. And he states that, well, all of this would have come out if I had deposed his expert, which I am under no obligation to depose him. And I can see, Judge, you're going to tell me about time here. Okay. And I'm not only I'm not under an obligation, yes, I made a conscious decision not to depose him because he did not have that information in his report. He did not have damage information in his report, and that was a fatal part of their case, which Mr. English was managed to maneuver and backdoor into the case and get it in.
With that, your time is up. Thank you both
Joan.
for actually very good arguments. We will take the matter under advisement, issue a written decision in due course. It will be mailed to both sides as well as posted on our website and the Supreme Court's website. Thank you, gentlemen.
Great, thanks, Judge.